Can I shoot? Can I fire the torpedoes? Okay. I'm going to call to order the July 18, 2017 meeting of the City of Tallahassee Ethics Board. It is a couple minutes after 4 o'clock in the City Hall City Commission chamber. I want to announce that Ms. McNeil and Mr. Grant are excused. They are both traveling, and Mr. Smith is going to be late, so we do not have a quorum. I'll put in a plug again for our 7th member because it takes 4 to have a quorum of 6 and 4 to have a quorum of 7. So until Mr. Smith gets here, we will not do any formal business. We will just do informational items. So I'm going to be skipping around a little bit on the agenda. For instance, I can't do approval of the minutes because we don't have a quorum. So on the ethics officer report, I have one request to speak, but let me get through a couple pieces of it. First, Ms. Meadows-Keefe, would you go over the report of activities for the month?
I will go over the activities for the month. This month involved finalizing a bunch of documents I've been working on for a while with the help of Ms. Phillips. And that'll be later in the agenda where we'll take a look at the handbook. There have been the usual meetings and development of some PowerPoints. So those are highlights from the month. Okay.
The second thing that we would normally do here is complaints, and let me recognize you in 1 second. What I want to say is we have 3 complaints. One of them is a holdover from last month that we, the board decided to leave pending. The other 2 are newer complaints. I am going to announce right now that I'm going to ask that Ms. Meadows-Keefe schedule a shade meeting and that we cover all 3 of those at our next meeting when hopefully we'll have all 6 of us here. And if she can get us, we've gotten a little bit of background on these. If she can get us whatever additional background is gettable, short of any kind of formal investigation. So we will be following up on all of those. And now I would recognize you for whatever comments you may have, sir.
Thank you, Mr. Chair and members of the board. That's a little bit of what I did want to comment on in the ethics officer's report. Just have a little bit of a concern of why there seems to be a reluctance on the part of the ethics officer to actually investigate complaints. And you look on the ethics officer's report, for the month, and attended city commission meeting, provided responses to staff inquiries, discussed with Florida Commission on Ethics referral process. Nowhere does it say investigated an ethics complaint. And I think that, the folks that passed the charter amendment, envisioned having an ethics officer that would investigate, complaints that citizens file. Also wanted to point out that in the charter amendment, there is a specific authority granted to the board to refer ethics and corruption matters to appropriate enforcement services. I know we're going to have a presentation later in the meeting as far as the referral process to the Ethics Commission, but I just want you to know that in 2013, as is reflected in the report on the process, the legislature created 4 new referring authorities to refer complaints to the Florida Commission on Ethics, and the idea was that these referring authorities could take anonymous complaints, and if they felt like they needed to be investigated, they could refer them to the Florida Commission on Ethics. And the 4 authorities are the Governor's Office, Florida Department of Law Enforcement, the State Attorney, and the U.S. Attorney. And so I would think that as you go through the process of looking at complaints that get filed here, you have to make a determination when the charter says appropriate enforcement authorities. You have to look at each complaint, and if you find that you do not have jurisdiction of that complaint, you then need to consider the merits of the complaint, whether the complaint is factual, and that would take an investigation by the ethics officer to make that determination. And then the board makes a decision of whether you should refer the complaint. I know you're going to probably say that you can't refer a complaint to the Florida Commission on Ethics. We hear a lot of, you can't do this, you can't do that, but this board can refer anonymous complaints to those 4 referral sources that I just outlined. And then they would make the decision of whether they would refer it on to the Florida Commission on Ethics. I'm glad to hear that of the 3 complaints that have been filed, that you're going to go into a shade meeting and consider those. I would hope that there would be some kind of investigation, so you have more of the facts that were outlined in the newspaper reports that you've all seen. I would understand why you would possibly close the first complaint, because that complaint talked about the city's ethics code and whether there was a violation of the loyalty oath, and you've already determined that you can't enforce that. So maybe that should be closed. But that same complaint involving those 2 newspaper stories is also in the 112 complaint. And that's where I think you would take into consideration the results of an investigation, and then possible referring the complaint to any appropriate enforcement agency. I want to also point out that the one complaint, 111, alleging that the contract for services was improperly awarded, and you've seen the news story on that, and you know that it involves a city commissioner and a lobbyist who's also a vendor of the city of Tallahassee. And that complaint alleges a violation of the city's charter. And I haven't heard from Mr. Currington. I know you've said that you have jurisdiction over the city's ethics code, but do you also have jurisdiction over the city's charter? And if there is an allegation that the charter was violated, is that something that the ethics board can look into? That's probably enough for now. So
Okay.
Thank you.
Let me add a couple comments. In terms of the ethics officer doing investigations, we've kind of taken the position that a formal investigation would be the result of us having looked at an issue as a board and directing her to do a formal investigation. But the word investigate's a little vague. She does provide us with, on any of these things leading up to, once she gets a complaint, if there's additional information that would be a part of an investigation that she gets, she does provide it to us, and we subsequently make that available. So there is, while it's not the kind of investigation that FDLE might do, there is some background work being done, and we do come into each of these meetings more informed. So I understand your position, but we've tried to take the position that the board itself needs to authorize a full-blown investigation. So but we're trying to do some things short of that in terms of moving forward. In terms of pushing these into shade meetings, the position I've taken as chair is that rather than ask the board to make a decision, which would require a discussion in a public meeting to go into a shade meeting, is I'm just going to push us into a shade meeting when I think that we ought to be in one, or if any board member suggests that, then we'll go into the shade on those things, and we always will have more information in the shade meeting. Because it's difficult for us to have any kind of meaningful discussion in public when we can't talk about what or whom or when or how or why. And then the last thing goes to the breadth of our jurisdiction, and we now have a quorum, I would note. We have now twice made recommendations to the City Commission about expanding our jurisdiction, and we will continue to do that. And I think we have maybe not the same interest in that you do, but we have a parallel interest with you in seeing the jurisdiction of the board expand to be what probably you would describe as more meaningful. I won't put a descriptor on it, but that's kind of my view or my response. So I don't think we're far apart on these issues.
All right. And May I respond?
Please.
Yes, and thank you. And Mr. Butzine and I and Marilyn Wills were at the last City Commission meeting and spoke in favor of your recommended ordinance and urged the commission to adopt it. I guess we'll get an update on that, where that stands later in the meeting. I'm concerned that the board is using this, lack of jurisdiction, or this jurisdiction over basically a meaningless ethics code as an excuse to avoid investigations. And that's why I'm trying to suggest that there are other alternative avenues for you to pursue. And because you have those alternative avenues to pursue, it merits looking. You do have semi-jurisdiction over Chapter 112, because you should be looking at things to see if it merits referring it to one of these other enforcement agencies that would then refer it to the Florida Commission on Ethics, which would have jurisdiction. So,
Okay. Message is heard and received.
About my report now.
I think we're done on this, aren't we? On the tracking?
On the,
Yeah.
okay.
I think, because this is all, we'll be back on this next month. Then we're on the budget. Anything, Ms. Meadows-Keefe, unusual in the budget?
Well, you will note that we've been utilizing Mr. Currington a bit more because you've been asking for opinions. Are you hearing us okay? Okay. You'll note that we've been using Mr. Currington a bit more because you've been requesting opinions. Likewise, when we go into the shade meetings, we do have the court reporter expenses. So with those meetings do come accompanying expenses. But other than that, there is nothing unusual.
Okay, and then finishing up item 3 on the agenda, I think you were asked at the last meeting to do a little summary report of the status of the various recommendations or interests that we have made known.
Correct. And so I just did this quick side-by-side analysis of things that the board had suggested, recommended in its 2 letters, and the progress that has been made on all of those items. And the city has progressed forward with many of those. You may want Mr. Currington to talk about it, but the city attorney and Mr. Currington have met to discuss our draft ordinance language and our interest in obviously getting that before the commission for a vote. I do want to update everyone quickly that there had been an intention for the chair to be at the city commission meeting tomorrow. That was to be on the agenda, to my understanding. However, I was advised last week that since this is the last meeting before the summer break, they have a lot of business to attend to. And then in September, they are dealing with budget, and then they're canceling their first commission meeting in October, that our item will be moved until October the 25th. So I expressed concern about that, that we had hoped to obviously get this on the agenda sooner. The flip side of that is that this will afford additional opportunities, hopefully, for Mr. Currington and Mr. Shelley to work together on language, and maybe by then we'd have something that the commission could vote on rather than just presenting letters and draft language. So we're hoping to achieve that goal during this delay period. I also wanted to let all board members know, just as a point of information, that I am seeking a board of directors seat on the Southwood Homeowners Association. That is permitted I cannot run for office, so I could not be on the Community Development District Board. I obviously can't run for any local office. I am permitted to run for my homeowner association board of directors, and so I am doing that. So if you hear scuttlebutt about that, it's true, I am, and heaven help me if I win. It's the first time in Southwood there's been more than one candidate. So I wanted to just let you know in the interest of transparency about that.
And I will point out that Ms. Meadows-Keefe and I have had a couple conversations about that, and have agreed that if there's anything that comes up that would ever come before this board that would even hint at an overlap there, she will recuse herself. So
Absolutely.
we've already worked out the details of how that would work. Ms. Phillips reminds me that I need to go back to item 2 on the agenda for approval of the minutes from our June 22nd meeting. Does anyone have any comments, corrections, additions?
I move approval as submitted.
Ms. Phillips moves and
Second.
Mr. Smith seconds. All in favor, aye.
Aye.
Opposed, like sign. Okay, the minutes are approved. That would move us to item 4 on the agenda. Ms. Meadows-Keefe.
Do you want to let Jerry talk about the meeting with Lou, or?
If Mr. Currington wants to talk about the meeting with the city attorney, he's welcome to. If he would rather wait, because we have an intervening meeting before the October 25th commission meeting, you are welcome to wait. I would leave it up to you, sir.
This will be very brief, so we can...
Please, just pull the mic down. Pull the mic down. There you go.
Thank you. I did meet this morning with the city attorney, Lou Shelley, to discuss this board's recommendation that the city commission adopt an additional prohibition in the city code of ethics. He indicated that the city commission has put it on their agenda for their October meeting, and that they have expressed a willingness. They have a few concerns. It sounds like they may want to tweak it in a few instances, but I'm not going to presume to speak for them right now. But I was pleased with the fact that they were receptive to the recommendations and will publicly discuss them at their next public meeting on October 25th, I think.
Well, outstanding. And I would remind the board that at your request from a couple meetings ago, I've now had the opportunity to meet with all of the commissioners. I missed the mayor's meeting, totally my fault. Just to kind of introduce, outside of, since they don't come here, that I would go see them. And I think that's something we probably ought to do, have the chair of the board maybe once a year go around and just say hi to everybody. And this issue of expanded jurisdiction came up, and all of them have been thoughtful and certainly welcome to entertain a discussion. They've all said, love to listen, love to talk about it with you. I'm not going to guarantee I'm going to do what you ask, but I recognize it as a legitimate issue. So that I came away with that from those meetings with a very positive feeling. Ms. Meadows-Keefe, are you going to do the CRA?
I'm going to do 2 in
Okay.
rapid succession.
Okay, and I would point out, I asked Ms. Meadows-Keefe because the CRA has been in the news a little bit, this is not a presentation about the city of Tallahassee, Leon County CRA. This is a presentation about what CRAs do, how they work, what the money is, just as an informational piece for the board and for anybody who is sleepless enough to watch one of our meetings on the interweb.
I did feel it was important that the board be educated on what these are. I did not know what they were when I came to work for the city. So it's something I had to learn. And then another question we may want to explore, Mr. Chair, and that would be up to you later, is to ask Mr. Currington precisely what authority, if any, this board would have over that entity. So as I describe the entity and how it's put together, you might be thinking about that, and that may be a future opinion you would order if you decide to. So again, we're just going to talk about real quickly, and we're not going to express opinions about whether things are good or bad. This is just what it is. So community redevelopment agencies. And I borrowed from a few very helpful presentations that I found online. The Tallahassee CRA has a website. CRAs around the state have a website. And then there was also a very helpful OPAGA study from, I think it was this year, about CRAs. So these are being looked at all over the state, and I want to say that there was a bill during this session about potentially sunsetting CRAs. That bill did not make much progress, but it may return. So there was a similar investigation in Miami-Dade about CRAs, and so there was like a grand jury, and they put together a report, and there were no prosecutions involved, but they made some recommendations about best practices. So this is representative of just people looking at it. But there's 224 that are active in Florida. They're from Alachua, not county, the city is Alachua, I think, and to Zephyr Hills, and from Escambia to Miami-Dade. And so they are all over the state. And this is just a quick slide that tells you some information about them. They are old. They've been around since 1969, and they were initially designed to cure areas that were blighted, that were eyesores, where there was a lack of affordable housing for people, and furthering public welfare, and to take areas in the community that need to be redeveloped and provide a mechanism for doing that. In 2002, so it looks like the act existed in its state unrevised until 2002, which is pretty impressive for something to last that long without revision, that the lack of affordable housing is no longer an independent reason for creating a CRA. And I'm going to also give a disclaimer here. Please don't consider me an expert on CRAs. This is for CRA 101. If it was going to be 301 or 201, I wouldn't be doing it. But these are methods for localities to create CRAs, and these are all referenced in the CRA statute that first there must be a finding of necessity. Next, a county or municipality may create this body, and it's called a CRA. And the process involved in doing it is similar to the process that's involved in starting a new municipality. So they go through, it's an arm of local government, really, and it's an independent local government entity, right? And so community development districts are kind of similar. It takes a part of the community and focuses resources on it. So it's considered to be a public instrumentality, and it has powers conferred to it by statute. And Chapter 112, which is the Florida Ethics Code, does apply to community redevelopment agencies, as does 119, public records, and also public meeting law. So all of this comes with it, all the things that go along with being a public agency in Florida. In Tallahassee, we have citizen advisory boards for our CRAs that are comprised of citizens that live in that area. So example, the Frenchtown CRA has the Citizens Advisory Board that brings citizens together to talk about issues that are then brought to the CRA. So they can have subcommittees. And so what do CRAs do? And again, this is from the most recent OPAGA study that was done. First of all, it's to enhance appearance of residential or commercial areas. So for example, here in the downtown area, some buildings had edifice or facade work done. And then as you're coming down, for example, now South Monroe Street, you'll see like there's a strip mall with a church, and it looks like that strip mall and church is getting kind of a facelift on the outside. They don't go inside and give you new decor or fix stuff wrong inside, but they try to improve the outer appearance of things. Second is they rehab commercial properties, and that's obviously for the reason of employing people, bringing more jobs, revenue and opportunities into these neighborhoods. And then the other two are related to infrastructure. One is transportation, and the second one is utilities. So for utilities, it could be things like perhaps undergrounding utilities, which is extremely expensive, and transportation infrastructure can be things like sidewalks and roads. CRAs are funded through, and here's the statutory reference, Chapter 163, and it's financed through tax increment financing, and they call these TIF Funds for short. I'm getting out of my comfort zone real fast here.
Ms. Meadows-Keefe, let me do this one.
Oh, great. I'm so excited.
Because I know this one.
Okay.
When the CRA starts to do business, before they do any work, what they do is they go into the area that's going to be affected and they look at the taxable value of the real properties there, the ad valorem taxes that are paid. And that becomes a frozen value. So the city and county will always get that amount of tax out. Then the CRA does the improvements, or working in partnership with people, the improvements get done. And presumably the values, the taxable values go up. So that increment up above the frozen value is called an increment. The taxes are paid to the city and county. This doesn't affect school boards and special districts. It affects primarily cities and counties. So the ad valorem taxes are paid to the cities and counties. They keep the frozen value piece that was already there. Then whatever the increment is, presumably growth in property values due in some measure at least to the work performed by the CRA, that increment gets transferred from the city and county over into the CRA's account or CRA's trust fund, and the CRA then is able to spend that money.
That's exactly what I was going to say.
Well, it's good to know we're on the same page.
Very artfully. They actually benefit not only the city and county, but also that specific area. So part of that money is reinvested ostensibly back in that area to continue with the improvements. So I appreciate that. And you should all take a budget course from Chair Herring, because that's his thing. So I've already talked about how the CRA officials are subject to the state ethics code. This is language I basically lifted right out of the statute, and there's protections built in there for people that own property within the CRA. If there's votes, there is supposed to be disclosure of that ownership ahead of time, and they aren't supposed to experience undue benefit from that. So that is addressed in there. In Tallahassee, we have 2 CRAs. They were established in 1998, so they've been something we've had for many years. And again, the purpose was to create a framework for redevelopment and enhancement of 2 specific areas in Tallahassee, and that's in the Frenchtown South Side community in 2000, and then the downtown district redevelopment area in 2004. So those are the 2 that Tallahassee has. And all CRAs have governing boards. The governing boards are comprised of different types of folks, but they are generally elected officials from the city and county. Not all CRAs have county officials on them. They can have just city officials, and then they can also have members of the public. So there is some ability to be flexible with who is on them, but generally they have elected officials on them with that level of accountability that elected officials bring to the table. So in Tallahassee, all of our city commissioners serve on the CRA, and then there are 4 of the county commissioners that serve, and the county commission appoints those 4. The chair at this point is a county commissioner. And these are just some sample projects that they have done. Some of them you may have heard about. People may have talked about them. But these are some of the things that have been facilitated through the CRA in Tallahassee. And that is the end of the very informational CRA 101 presentation.
Okay, do any members of the board have any questions for Ms. Meadows-Keefe? Mr. Davis.
I have just a quick question. You mentioned the Citizens Advisory Board that would be helping sometimes in providing information to a CRA, but when a CRA in Tallahassee, for example, would come towards making a decision to allocate, let's say, $2 million per project, is there a public notice of that issued and decision about to be made so that any other members of the public could attend a meeting and voice any thoughts one way or the other?
Absolutely. In fact, some of the most spirited meetings I've attended have been those Citizen Advisory Board meetings. So the citizens do come, the citizens do participate. There is notice given, just like we give notice for this meeting, and the people do come. There are sometimes complaints when those meetings get canceled. They get canceled sometimes, maybe due to lack of a quorum, or they don't have a lot of business to take care of, but they do meet and they do take a lot of public comment.
Okay, thank you, Jim.
Other questions? Okay, Ms. Meadows-Keefe, I believe you're going to go on to the Florida Commission on Ethics complaint process?
Yes. And again, this was something that you had asked me to do and that we had talked about at the last meeting because of comments we've been receiving about potentially referring matters to the Florida Commission on Ethics. And in talking about this and preparing for it, I also have had conversations with some staff that I know at the Florida Ethics Commission to make sure that if we did proceed with referring matters, we would do it appropriately. So first of all, this is actually different than the city process. So we made our complaint process very quick and easy, simple, and anonymous. Okay, so that was done on purpose so that people would not feel chilled in their ability to complain. The Florida Commission on Ethics does not take that approach. So the Florida Commission on Ethics requires a sworn complaint. They require some degree of knowledge that this issue is actually taking place. So I'm going to get to direct referral sources, as Mr. Wilcox referenced later, but they do have a different process than we do.
And Ms. Meadows-Keefe, I would note that while our process, we had a lot of ability to decide that our process would be more open, you can't really say it's the Commission on Ethics. To a certain extent, their requirements are what the statutes say they shall do. So it's not like they've tried to close the complaint process or chill the complaint process in any way. They're simply following the law.
Well, right, and much like this board asks the City Commission for additional authority and provisions, likewise, the Florida Commission on Ethics habitually asks the legislature for things that are sometimes granted, sometimes not. So you're correct that they deal with the law that they're given, and the law there says that people want sworn complaints. How it's similar, though, is that once a complaint lands at the Florida Commission on Ethics, it is confidential, just like ours is, until they make a determination regarding whether they're going to move forward with it or not, at which point everything becomes public record. So that is a similarity. So what do you have to do to file a complaint with the Florida Commission on Ethics? So there are a few bullets here about you have knowledge that a person has violated standards of conduct or disclosure laws or some other violation potentially of the public trust. So although newspaper articles, I did talk about this with the General Counsel at the Ethics Commission, newspaper articles are okay, but you cannot simply enclose an article. In fact, if you enclose anything, your complaint is returned. So you actually have to write down and incorporate into your narrative the allegations in whatever document it is that you're talking about, and you would cite to whatever periodical that it is, but you are actually writing it down yourself. And there is kind of a assumption that you're going to have some personal knowledge over and above what's contained in the article. The complainant also needs to have some familiarity with the Florida Ethics Code, which I think all of you guys do, and I do, what you believe the official did that violated the Florida Code of Ethics. So there is a little bit of work involved in filing such a complaint. Complaints must also be sworn before a notary or other official authorized to administer oaths. If it's not sworn, it's returned. And you are required to submit an original form. So you sign it, notarize it, and you send it that way. So again, that's different than our process where no one has to sign or notarize anything. Also, because I think the legislature recognized or believes that sometimes ethics complaints can have a political motive attached to them, that you cannot file a complaint with respect to a candidate within 30 days immediately preceding an election unless the complaint or referral is based on something you know yourself, not something that you, for example, read in the newspaper, because they don't want to deal with those politically motivated right before an election type of complaints. They also have a statute of limitations attached to them, which is 5 years, and then it talks about when that statute begins to run. So far, this board hasn't, I don't believe, talked about a statute of limitations. That may be something you want to talk about in the future. And Mr. Wilcox did talk about direct referral authority and what referral agencies are allowed to simply just forward on a complaint to the Ethics Commission, and those are again listed for you there. You'll note local ethics boards are not one of those referral sources. And while this board may have the option to send a complaint that's anonymous to one of these people and hope that they directly refer it, the chances of that actually happening through one of these is probably unlikely. So the way that this board most likely would get a complaint to the Florida Commission on Ethics is that someone is going to send it there pursuant to the method that I described. So here's what happens once the complaint arrives. The subject gets the complaint. So whoever the complaint's against is going to get notified, hey, there's a complaint against you. And then there's going to be a preliminary review, much like I do. They're going to look at it and go, is this legally sufficient? So if the facts, if proven true, come out, is this a violation of a provision of the Florida Ethics Code, yes or no? So if yes, it proceeds to investigation. If no, it's closed. It's investigated, a report is prepared, an advocate then makes a probable cause recommendation, and that proceeding is closed to the public, and the complainant and the subject may have counsel. So that means, for example, if this board, through a member, sent a complaint, ostensibly the complainant is allowed to have a lawyer there, as is the subject. So that'd be something that this board would need to talk about, that there is that ability to have counsel to talk about why a complaint was filed. So then there's a process where they determine if there's probable cause, and it works a lot like ours does. If it's dismissed, all of the stuff then becomes public. You can have access to what was said and all the documents. If the commission finds there's probable cause, again, it still becomes public, and then it's referred to DOA unless there's a settlement reached before that stage is reached. So a lot of them do settle pursuant to stipulation. Then once there's a final order, if the ALJ has made a penalty recommendation, the Florida Commission on Ethics is the person or the entity that will actually levy that penalty, and they can change the penalty if they don't agree with it. However, they have a really hard time modifying findings of fact because the administrative law judge is the fact finder. So they get that, and then they levy a penalty, and then the subject of the complaint can then file an appeal with the DCA. For us, our appeals go to the circuit court. So penalty stage, I've already kind of talked about that. They can recommend penalties. And this is something to be aware of, attorney's fees and costs. If a complaint's dismissed, the respondent doesn't automatically get attorney's fees. So there's not that worry. You're not automatically going to have to worry about having attorney's fees assessed if the complaint fails. However, the subject can petition the commission to have their attorney's fees paid. And here's two criteria that would be looked at. If you can show the complaint was filed with malicious intent, two, the person filing the complaint knew the statements were false when they made them and were filed with reckless disregard for the truth, which is a different standard than in First Amendment law. I want to say that in case anyone's thinking that. And three, the statements were material. So it's a rather high bar. The chances of getting attorney's fees assessed against a complainant is not high, but it is something that's possible if it meets those criteria. Here, there was a particular complaint that was dismissed, and the allegations were legitimate and founded in fact, but there was a lot of inflammatory hyperbole included in the complaint document. But the court believed that hyperbole in and of itself, the exaggeration, the highlighted language did not allow the person to get attorney's fees back because the facts and the violations alleged were legitimate. So Again, this is just a quick overview. We've talked about this in the past. There are some open questions for this board to consider as we move forward in thinking about how we refer matters over to the Commission on Ethics. Assuming we're not going to send it to one of the direct referral authorities, as referenced by Mr. Wilcox and in my last slide, we're going to need to decide who signs the complaint. So the obvious choice would be the chair of the board, but this is a voting body. And there might be a situation where a chair may not wish to send it, but a majority of the board does. So if the chair decides he's a no vote, then the next logical person would be the vice chair of the board. If that person is also a no vote, then I guess I would suggest that the longest serving board member who votes affirmatively would need to be the person that would sign the complaint. And then these are just suggestions, by the way. These are just food for thought for this board. The complaint would possibly be drafted. I would draft it. I would work with Mr. Currington on that document like I have in the past with similar things. And then a board member would need to review that and be comfortable with signing it, and then would send it over to the Ethics Commission. The Ethics Commission will not take a group complaint. So for example, if there's a 4-2 vote, you're not signing that. Say Mr. Davis does it, I'm gonna pick on you. You're signing it. You don't get to sign it, Cecil Davis, as member of the Tallahassee Ethics Board on behalf of, you are an individual. So they aren't gonna take you as a member of a board, you're doing it. You can explain in your narrative that you are a member of the Tallahassee Independent Ethics Board and this was heard, and there is investigation done, by the way, on everything that comes in, and the board usually has access to additional documents. But so it would not be signed in a capacity as the Tallahassee Independent Ethics Board. There'd be someone with their individual name on it. So that is my presentation on that, and that's food for thought.
Questions of Ms. Meadows-Keefe? I'm going without a motion here. I'm going to ask if you would bring us at the next meeting, if possible at the next meeting, if not the following one, a draft policy on referral of a complaint to the State Ethics Commission that would address several of the issues that you just mentioned, like signed by the chair or the ranking member who voted on the affirmative side to refer the issue, that makes it clear that it would be with the support of the board. So presumably that person, even though the commission would be looking at an individual signature for anything that that person did, if for instance they went as the complainant before the commission, that they would say, I'm representing the board, to make it clear that as much as we can control it, it's a board action and not an individual action, and whatever else in the process that we need to lay out, so that we would be, at the point where we are ready to, where we vote to refer an issue, we've got something we know exactly step by step what we're going to do, how we're going to do it, and then let us look at those specifics as a board, and we'll fine tune them, and Ms. Phillips can correct us.
Do you want it in a bylaw, Mr. Chair?
Yes, that's what I'm thinking,
Okay.
yes.
Is that an affirmative nod?
Yes.
Okay.
Okay, and that's just my request to you, and we'll deal with motions and seconds and such when we have some actual language. And if people think that, you know, Richard was crazy last month and this was a stupid thing for him to ask you to do, then we'll vote that way, and I may vote in the affirmative. The next item is public comment on agenda items. Seeing none, we are to item 6 on the agenda. This is Mr. Currington has looked at the issue of us exceeding board authority and has both good news and bad news. I'd say primarily bad news, but you're recognized, Mr. Currington.
Thank you, Mr. Chair. Let me go ahead and frame the precise question, which was, what are the potential consequences or liabilities for the board if the board or one of its members exceeds its legal authority under the city charter or the city code of ordinances? Let me start with a few propositions of law by way of background. First of all, every public officer has the duty to obey the general laws, and in this case, the city ordinances and city charter, and that every public officer has a duty to devote personal attention to those duties. Along with those duties, I guess, again, there's some good news, and that is state officials and municipal officials are presumed to have acted in good faith. There's a presumption that people are trying to enforce the statute or the ordinance or the charter or the Constitution. So that's a nice presumption to start with. Conversely, neglect of those duties is grounds for suspension of office. So maybe first and foremost for public officials at least is if you exceed your authority, you can be suspended or removed, either in this case by the city commission or even possibly by the governor's office. So removal from office is one risk when you exceed your legal authorities. Also, public officials can subject themselves to extraordinary writs. We've probably all heard of writs of prohibition and writs of mandamus and writs of quo warranto. A writ of mandamus is a positive writ. That's where someone can go to court and force a public official to do their job. Writs of prohibition, a person asks a judge to stop an official from doing anything. And a writ of quo warranto is very similar, and they are frequently joined, and it really questions someone's authority of whether they can proceed, and it's more like a declaratory judgment, but again, it can stop the public official from acting. So if you don't have authority to do what you are doing, you may be subject to a legal proceeding in circuit court, typically, where someone will try to stop you from moving forward on that behavior. Next is possible civil liability. By way of example, if you defame someone in moving forward, you can be potentially liable to personal civil liability. There are a couple of things. I mentioned some constraints on public officials. Public officials are not permitted to act arbitrarily or capriciously, and they're bound to use due diligence in the performance of their duties, particularly where someone's personal rights are affected. So your reputation, by way of example. This board has a duty to be diligent before we slander or accuse someone of being unethical. Okay? And if we do that negligently, then there's potential liability. Okay? And then finally, there's maybe remotely, but the potential for criminal sanctions. If any of the board members as public officials falsify a record, that some behavior of public officials has been criminalized, and it's either a misdemeanor or a felony, so you could be subject to criminal prosecution if you destroyed public records or whatever. Even the failure to comply with the public records law sometimes can be a misdemeanor. So there can be criminal behavior. So those are really the four sort of exposures. And all of those are real disincentives to be a public servant. And you hear public elected officials say, boy, what's the point in serving? All I have is all this exposure. Florida law has created some mitigating doctrines to minimize that exposure. So let's talk a moment first about the personal liability for negligent behavior. Chapter 111.07 and Chapter 111.07.1 of the Florida statutes say a municipality can defend allegations of negligence. So if one of you board members were sued for defamation, the city has the authority to hire a defense lawyer and defend that action. That's 111.07. And under 111.07.1, they have the right to pay the judgment. If for whatever reason you get an adverse ruling, they can actually pay the judgment unless, and let me get that language correct here.
I thought you were going to say pay the judge.
Judgment.
I'm thinking, no, I don't think so.
Okay. So they can pay the judgment if you act hypothetically negligently, but you do not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Okay? That is phrased in similar terms. You'll see language that says if you exhibit wanton or willful disregard of rights, safety, or property. So in those cases, the city could decline to pay the judgment, in essence, if you act in bad faith. Okay? All right. So in addition to those possible civil liabilities, there's another defense and another doctrine that protects public officials, and that is immunity, the doctrine of immunity. And there's either qualified or absolute immunity. This board enjoys absolute immunity when it acts in a quasi-judicial function. When does this board act in a quasi-judicial function? When you adjudicate guilt or innocence on a charge of an ethics violation. So if you find a state or a city employee or official guilty or innocent of a code violation, that is a judicial act, and it is absolutely entitled to absolute immunity. The suit can't even be brought, basically. It should be thrown out of court, because immunity is a doctrine that says government, in essence, can't function if judges can be challenged on their motivation. If everybody could accuse the judge of taking a bribe or do this, it would make our court system dysfunctional. And so they've granted absolute immunity, and it's based on the old English doctrine of the king can do no wrong sort of thing. Okay. What happens when you're not acting in a quasi-judicial capacity, but merely as we can debate whether this is an executive or legislative body. The State Ethics Commission is considered a legislative body, and so but whether this is legislative or executive, the standard is the same, and you're entitled to qualified immunity. And so, provided you are acting within the scope of your authority and not ultra vires. And in my opinion, I actually quote the Black's Law Dictionary for the definition of ultra vires, which are those acts performed without any authority to act on the subject. Okay? You as board members can't go out and arrest somebody. You've got no authority to arrest somebody. And if you do it, then you may get charged with false imprisonment or whatever, okay? So qualified immunity may not cover that when you have clearly no authority. It's designed to protect you when you are acting in good faith and making discretionary calls within your authority. So I guess that's it. I can summarize it if you would like, but I think that covers the waterfront.
Questions, Mr. Currington? Mr. Davis?
I'm trying to understand how that might apply to this situation. So let's say the Ethics Board investigates a matter and believes there's probable cause that an ethics violation has taken place, but it deals with misuse of public office. And we know that there's not an ethics code provision under the city ethics code that allows us to proceed with that type issue at this time. Are we exceeding our authority to recommend, to refer that type finding to the State Ethics Commission or some other law enforcement group or appropriate referral group? Or are we limited?
Let me try to answer that, because there's a gray area there, number one. First of all, the city charter says that this board has the authority to refer ethics and corruption matters to the appropriate enforcement agencies. So we've heard over the course of a number of meetings that we have the ability to refer to an appropriate agency. Now, we haven't spent a lot of time on defining what an appropriate agency is. Today we heard that maybe we don't have the authority to send it straight to the Ethics Commission, but we'd have to refer it to a state attorney, a U.S. attorney, whatever. In the city commission cannot change Chapter 112 by writing this into the charter. So even though the charter says we can make referrals, it doesn't mean under 112 the Ethics Commission has to take them or that they were proper referrals. Okay? So it may be an improper referral, But you can make mistakes of fact and all that I don't think would cause you to lose your immunity defense. That is designed, essentially you are protected unless you intentionally cause the harm, or you intentionally, what a reasonable person would have known, you had no authority to do. So, Mr. Davis, going to your hypothetical, I have suggested you have no authority to prosecute someone for misuse of office. So if you try to prosecute them yourselves, you may have stepped over the line because you've gotten legal advice. You don't have authority to do that. Making the referral is arguably a gray area, and I would suggest, absent what a knowing person would know where the gray areas are, the purpose of these laws are not to make public officials vulnerable because they make mistakes or the law is unclear. Okay? So using that hypothetical, if you tried to prosecute for the misuse, you may be vulnerable. If you simply make the referral, I doubt that you would be liable. Does that answer your question?
Well, the doubt bothers me.
Yeah, well.
But because, you know, we've been frustrated at times with the limitation of our authority based upon the City of Tallahassee Ethics Code. And there could be the desire at times, and well, I don't know if the desire is right, but if you felt that it was appropriate under all appropriate ethics laws and the laws you've discussed in your letter, to take the step of investigating if we found a factual basis for probable cause and that we could refer it to another agency who did have an ethics code provision that was broad enough to cover it, like an abuse of office provision that's the code provision that the Chapter 112 would have, and the city and the state ethics commission could investigate. That would be a good practical thing, it seems to me, for us to have the authority to do. But if we're stepping out in shallow water and tiptoeing on our own ethical problems, I'd never want to do that. I'd want to avoid. I'd hope our board would avoid the appearance of impropriety, just like a judge should avoid even the appearance of impropriety. But that causes me to wonder, is it right or wrong for us to consider that step?
Let me try to answer it by saying this, Mr. Davis. First of all, if you do make a referral, I think if you make the referral to one of those 4 referring authorities, I think you're probably very safe, okay? You're very safe. And I think the city probably here under Chapter 111 should defend you, because the city, in essence, has asked you to make the referrals to the appropriate agency. It sounds like those 4 referring agencies are appropriate, and therefore you've exercised judgment, and not only should they defend you, but they should pay the judgment if you are wrong, okay, if you make the referral to them. Now, really, I hadn't given this much thought, but if you make the referral directly to the Ethics Commission, and again, these are fact-intensive questions, but we arguably know that we shouldn't be making to them because Chapter 112 doesn't contemplate it. So I don't know how a trier of fact would weigh those facts. Yeah. So I would say to you, make the referral to one of the 4 authorities, but not to the Ethics Commission.
Well, okay, so,
Other boards have referred to the Ethics Commission, though, in that way that I described.
okay. Mr. Davis? Hello? Mr. Smith? You good? Okay, I think fact-specific is where we're going to leave that one. I cannot imagine that over the course of time we won't do referrals to whoever's appropriate. Mr. Currington?
One more thought comes to mind. I think any board member individually that felt strongly enough about it could personally file the complaint with the Ethics Commission, and you, on a personal level, are okay. I mean,
even though, and that would be a situation where the information available to that board member would have been obtained probably in a shade meeting of the board. But then once the shade meeting's over, that information all becomes public, so.
right, I'm assuming you've not violated any confidentiality provision or whatever. I'm addressing the point that you, like any citizen, have a right to hire some. But if you've got something in confidence, again, this board can't misuse its authority, can't take insider information or confidential information and misuse it.
Yeah.
Right.
I continue to think that if we look at an issue and it's outside our jurisdiction, but we see as a board, at least the majority of the members believe that something is clearly a violation of the ethics law, that we as a board ought to be able to act, even though we authorize an individual to act in the stead of the board. And I think in those in a case like that, that would be fact specific, we'd be back in your office saying, you know, tell us how you're going to we're going to do this. Tell us how you're going to defend us. I think would be our question to you at that point.
It's prudent. And I think that would be prudent. But let me say something with it's always terrible to say with all due respect to Mr. Wilcox, we don't see eye to eye on this. But there is a problem here, and it's within the drafting of the charter amendment, because it uses the language that this body has the authority to investigate complaints for violations of the city code. Right. This charter amendment ties the hands of this board. We have the right to investigate. If I didn't like these board members, I would sue you saying, well, this doesn't give you authority to investigate Chapter 112, and you're misusing tax dollars or whatever. Now, again, my advice is to give you what the law says, not what we would all like it to say.
Okay. Fair enough. Other questions, comments? Ms. Meadows-Keefe, anything?
No.
All right. We are moving on to, a break. Item 7 on the agenda is a break. This is a good time for a break. We will be back. I can't see the clock. What time is it?
It's 5:10.
5:10. We'll be back at 5:25.
Cecil's?
Item 8 on the agenda, I apologize for being late, is 100% my fault because I am a gabby person apparently this afternoon. Keep me away from caffeine. We have before us the Citizens Ethics Guide that Ms. Meadows-Keefe and Ms. Phillips have been working night and day, shoulder to shoulder, eye on the ball, nose to the grindstone, shoulder to the wheel. I don't know how you work in that position, but they've been in it.
That's why you didn't write it, by the way.
I was
It's-
not involved at all, so it's pretty
all of
good.
those run-on sentences. Ms. Phillips helped me with some of that. But we know that part of the responsibility we have is to educate the public on ethics standards. And both the charter amendment and the city code referenced preparing a city ethics guide. And it's supposed to be for citizens and employees. So we've been working on this on and off for several months, but we finally actually got a draft that both of us were happy with. It is, and actually I will say it was fun. Working with Ms. Phillips on this, and we got a real good dynamic going with working on it. And the reason it's here for you to look at is that I plan to put this in some final form and try to get it out on the city website at least post haste, because this has taken a while to do and it was a priority. So we want to get it out. We are going to have it available on the web, and we are also going to have a printed version available. We do want it to mainly be web-based due to cost. And we know people aren't so fond anymore of printed documents, but after reviewing several potential formats for the print version, we arrived at, Sunny and I, or Ms. Phillips and I arrived at this format. This document that I'm holding up is the Florida Commission on Ethics Guide to the Sunshine Amendment and Code of Ethics for Public Officers. So we looked at larger formats like booklets, more glossy, but our thought process with this shape of document is that a gentleman or lady can place this in a pocket and it's not cumbersome to carry around, and it'd be something that could be placed, say, on the back table for a city commission meeting or a meeting like this, and then easily passed out at community meetings where I may go or a board member may go to talk about the ethics board. The language in it will also be used to update our website to talk a little bit more about the board. So the reason it's here before you today is to kind of get a blessing of sorts that you guys are okay with this pamphlet format, that the, actually it's a booklet. I wouldn't call it a pamphlet, I would call it a booklet because it's got around 30 pages in it. It doesn't have a lot of white space. Our product will have a little more white space, so it's not intimidating for people sometimes when they see big blocks of text. And we did try to use some plain language. And so the question that I had, and I think Ms. Phillips, is we just wanted to know any feedback, any parts that you think we left out, any additions, corrections, revisions, general thoughts.
Okay, anyone, questions? I will tell you, I read it, as with any document, including things that I've written myself, I would probably edit, but I'm fine with it.
I'm happy to accept edits if you want to send those to me.
Well, I've read it enough times that I think it's good too.
All right.
Julie did a good job.
We both did okay on it.
Particularly since it's going, if it's electronic, it can get adjusted in the future. And a print copy, I assume we wouldn't be printing 20,000 of them. It would
Absolutely.
be a much smaller print run. Is this something that can be done internally at a low cost?
I'm hopeful that it can. I will admit, I want it to be an attractive document. I want it to be more attractive and appealing than this. I want it to be something maybe with a dash of color on the front, with something someone might be motivated to pick up. So I'm going to try to have it done in-house. I think it is possible to have it done in-house. And I am going to do an initial print version of not that many. And then, of course, if it's in a PDF format on the web, a person could simply print it out themselves if they wanted a print version.
Okay, and it'll be formatted on the web, I assume, for 8.5 by 11 printing?
Yes.
Okay.
For normal size pages like this, not
you
to
want-
print out like that.
So if you want people to pick it up, you're going to put like a picture of a cat playing the piano or something on the front?
I have not chosen the meme yet,
Okay,
but it will be great.
it will be great. Anyone have any comments, any concerns with moving forward on this? Okay, since it's one of the things we're supposed to do, it's going to move forward. The city auditor's survey. I think everyone's received a copy electronically, and I believe the city auditor is going to come to the mic and tell us that he wants us to give him work. I think that's what he's going to say, which I questioned.
Well, this is the time of year, July, when we start trying to determine what we're going to look at in terms of audits for the next year. I think as I told you last year, it's kind of a two-step process. We do an internal risk assessment within our office, but we also, very importantly, solicit input from different groups, including the mayor, commissioners, the management team, and the different citizen advisory boards and committees, which includes you. So we get all that information, we massage it with the limited resources we have. We decide what we can look at that will best benefit the city, and present that to our Citizens Audit Committee and to the City Commission for approval. So appreciate whatever input that y'all have that you want to give us. You can give it to us tonight, or you can respond on the website as individuals. So,
Okay. Thank you. Ms. Phillips.
I actually tried to respond on the website, and I couldn't. So I'm going to the wrong link or whatever. The survey, I never did get the Survey Monkey. So I let Michelle know, but I just hadn't heard back. I mean, she said
Okay.
something about the survey would be available tonight or something, but
we'll check into that.
it might be
good.
just that I'm ignorant enough to not be able to get it, but.
We'll check into it and get back to it.
But do you have the survey available for us to complete, or?
I can get them for you. Certainly. I don't have them right here, but I
Okay.
can get them to you before the night's over with.
Okay, yeah, that's fine, or just, but I did note that you had done a audit on travel in 2012 or 13. I didn't know and all the policies that you had suggested, your audit has suggested, have been incorporated, improvements, et cetera.
We've actually done 2 travel audits that I can recall, and changes were made based on both of them. We did the follow-ups like we do on all our audits, and the action plans were implemented. I recall in that audit, one of the significant actions that were made was changing the reimbursement per diem rate,
Right,
which was a more reasonable rate
right.
than what we've been using before.
And it was interesting that a very low percentage actually of problems were actually seen from that audit. So that was encouraging, because that's a good place to manipulate the system.
Right, absolutely. Okay, well, any input that you want to give us, we will appreciate it.
Okay, thank you, Mr. Fletcher. Always a pleasure to have you here. All right, as I do at each meeting, I'm going to ask if there are any board members who would like any specific items placed on next month's agenda. Anything of particular interest? Seeing none. let's see, what does it have on the agenda here? Process regarding complaint review, complaint document review.
Right.
Ms. Meadows-Keefe, you're recognized.
I did want to point out, and I don't know if this belonged in my report or not, but it probably also belongs in a bylaw, that what I have implemented with, after consultation with the chair, is when complaints come in from the public that have documents attached to them, I have now started mailing those documents to the individual board members, so that when we get to that time in the agenda where we're talking about complaints, the board members will have the documents. They will have had a chance to review those. So that's, I think, a process tweak we made to improve their ability to comprehend what complaints are about, while still respecting the confidentiality of complaints at that time. So that mailing process, we've listened to some of the things you've said and tried to address those. So I did want to point that out, and probably we need to incorporate that into our process through a bylaw, so that anyone coming after will know to do that.
Okay, so that would be for our next meeting.
Yes, a bylaw for that.
And then the other thing here, and this may be a question for Mr. Currington, consideration of complaints. I assume this is complaints about actions that occurred before the board's existence. Have we not talked about this before, our ability to reach back to things that happened before the board was created? And as I recall, we've had a discussion that our ability to look at those things or to sanction those things would be limited, because no one would have known that it was a violation, or that we would be able to sanction it. Does that ring a bell?
We had a complaint that was brought about a vote that took place about pension payments, and that was back in 2012 maybe, but it was before the board existed. Of course, the allegation was the ongoing payment was the violation, but does the board want to have that cutoff, that we're not going to go back in time before the board existed? Do you want to have that or not in some kind of policy?
Microphone, please.
Sorry. Julie is correct in pointing out, we did look at that because it was an ongoing violation. And I think, Mr. Chair, what you're alluding to is, in my PowerPoint, I was suggesting that we can't retroactively prohibit behavior that occurred before this code was adopted. I don't know if that answers your question.
It's just a house cleaning.
So something in the bylaws that would say that we would, I don't know, maybe it needs to be contingent based on specific facts. We generally would not look at or investigate activities that occurred prior to the existence of the board, and particularly prior to the existence of the ethics ordinance, but that would not foreclose us looking into any of those activities to the extent they continued to occur after the date of the creation of the board. Is that correct?
Got it. That's what I'm intending
Okay.
for that. And then for C, I do have the evaluation of myself, but I'm thinking that that will take place with the board's assent in September, so it's complete for the October 1 fiscal year, but I don't know if we'll have time in August to do it.
What I recall last time, didn't we give each one of the board members an evaluation form?
Yep.
And then they can all come, I guess, to me, and I'll assemble them and provide some data and try to guide us through a process where we reach consensus?
Yeah.
Follow the same process as last time?
Right, in September, if that's okay.
Whatever meets our timeframes
Got
will
it.
work, unless we have copious time in August.
Mr. Chairman,
Ms. Phillips.
can we also add just an update on the side-by-side that was presented this evening?
Part of the report.
Okay, that'll be part of the ethics officer report. Anything else to come before the board at the next meeting? Okay, any public comment on non-agenda items? Mr. Wilcox, you're recognized.
Thank you again, board members and the chair. I'm Ben Wilcox with Citizens for Ethics Reform. And just wanted to thank you all again for your service, and really appreciate the hard work that you're doing to try to, make yourselves a relevant body here in the community. It's I appreciate the chair directing that you develop a bylaw on possible referral process. Also, the bylaw on review of documents, and I appreciate the ethics officer, sending documents to the board members so that there's a little more clarity on these complaints that are coming before the board. I'd probably hope to speak for my fellow Citizens for Ethics Reform, and these meetings can really be exhausting, and they get discouraging because it just seems to be a litany of things that you can't do, and a litany of things that were hoped for under the Charter Amendment that you can't do. But I trust that you'll continue to work hard to make the board relevant here, and we'll continue to support your efforts.
Thank you, Mr. Wilcox.
Catherine Baer, sorry, I just wanted to say something really quickly about the side-by-side, and I know that this came from the commission, the right side of it, but we did want to address the last one on the city charter and on the process for the 7th member. We really like the idea of the president of TCC, and I know that you guys don't have anything to do about this, but when you talk to them about this, we're very concerned about the recommendations for the Florida League of Cities and the Chamber of Commerce due to their controversial nature of that. And we have a little bit of concern about the Public Defender's Office. We're not sure if, just because of the way it turned out with the Chief Justice, we're concerned about that. Them,
State attorney member, though.
which position was that chose not to appoint?
Chief
Judge.
Judge.
Chief Judge.
But the state attorney appointed.
Well, we're just saying the president of TCC appears to be the better choice on that one, and I don't know if you guys can do anything about it, but that was just our thoughts.
Okay, well, thank you. I have had several discussions with city folk about that. They were originally concerned, as you remember, in our recommendation, we said, just let the board appoint the 7th person, and they didn't like that particularly. And I get that, because we'd be appointing 3 of the 7. And they thought the idea of having another independent appointing authority, which is fine with us, but as you saw at the beginning of our meeting, we get in a position where we may not be able to field a quorum, and that's a frustrating place to be, whether you're a soccer team or an ethics board. So we will continue to try on that, and certainly from my perspective, people appointed by folks in education, it's just dandy. And Mr. Smith seconds that. With that, if there's no other business to come before the board, I will announce our next meeting is August the 15th, 2017, 4 o'clock in this same location, and we are adjourned.